If you Google the name Karen Read, these are the kind of headlines you're gonna see. But what you won't see or hear about is this.
But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. So to try to make a public record.
I speak to Chris and Julie Albert.
Have you spoken to them about these events between then and now?
About this case? Is that what you're asking?
Yes, Ms. McCabe, I'm asking about this case.
Of course, I speak to them all the time about the vicious harassment we are all receiving.
Okay, but that wasn't my question. My question was, did you talk to them about this case, Ms. McCabe?
Yes.
I realize you want to give additional answers in the editorial. I'm asking you a very specific question.
Talk about not opening the door. Hello, 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 and welcome back to Alexasrewm, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people who have opinions about all things going on in the true crime community, including who really opened the witness intimidation door. So this was actually shared by somebody on the Twitter X's. They replied to one of my tweets in response, or replied back to a response by Broken Baker, our friend here on this channel. So go give him a follow and subscribe on the Twitter X's as well as on the YouTubes. But this is actually discussing this very thing before the first trial, and who in fact is responsible for opening said door, and what the Commonwealth and the defense side agreed in regards to anybody talking or bringing up any of the witness intimidation or alleged harassment, right? Boo-hoo, Crimea River harassment during their testimony. So shout out to Just T on the Twitter X for finding this clip and sharing it with us.
And the defendant's motion number paper 288, regarding any reference to Aiden Kearney, aka Turtle Boy, or his pending criminal charges for witness intimidation. So both parties have agreed to not introduce this in evidence in their case in chief. If anyone opens the door, the motion will be revisited, and I think I said that I sort of disagreed with you both. I do think if witnesses testify to this spontaneously, then it comes in, and it can be pursued further, but just come to sidebar.
Just come to sidebar, and if they bring it up spontaneously, they are more than welcome to continue to talk and further elaborate on that. Let's play that back one more time.
So both parties have agreed to not introduce this in evidence in their case in chief. If anyone opens the door.
So both parties, meaning the Commonwealth and the defense, agreed, we're not going to bring this up. We have no plans to introduce this during the trial. We're both in agreement on that. There's not a lot of things that the Commonwealth and defense agreed upon this upcoming trial or the previous trial, but this is the one thing that they did, or one of the very few things that they actually did mutually agree upon to not bring into the trial. So why, Beverly? Why? Why do you feel like it's necessary to open the door and not take responsibility for it?
The motion will be revisited, and I think I said that I sort of disagreed with you both. I do think if witnesses testify to this spontaneously, then it comes in, and it can be pursued further, but just come to sidebar.
But just come to sidebar. Now, I want you to remember that as we continue this video, because that is going to come up in just a hot, steamy, stinky meatball minute. So that was on April 25th, 2024, just 4 days before the first trial began. So now let's fast forward to today's festivities, where yet again there was another discussion about whether or not the harassment or witness intimidation stuff should come in to trial once again.
Motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise.
Oh, you mean like this?
Now, you were asked some questions on cross-examination regarding whether or not you've been thinking about this case for the last 2.5 years. Do you recall that?
Yes.
And you indicated that you had not, correct?
Correct. Sorry.
And you had indicated in your testimony in response to that questioning, essentially not until people were writing things about you on the internet, correct? Correct. Can you expound upon that? Can you explain to the jury sort of when that occurred and what were the things that were being written about you on the internet?
I'd say about a little over a year. It started when people on Twitter, Instagram, social media were just coming at my family, calling us murderers, harassing us, showing up to our doorsteps, our sports games. I mean, we couldn't leave the house without people taking pictures of us, and it's very terrible.
But I also thought that you didn't go on social media. So how would you know, about all of these terrible things that are being said about you if you didn't have social media? And I'm not talking before the investigation. I'm talking about the in-between period, because that is when reports started coming out about the truth. How else would you know about people talking smack about you on the Twitter X's? So anyways.
You watched any coverage of this case online?
Nope.
No social media?
No, I don't have social media.
No news, coverage?
Nope.
Nightly news, Channel 25, Channel 5?
No.
WCVB, same news media outlet whose legal analyst is literally repping your uncle right now, Greg Henning. Yeah. What about that one? I bet you're tuning into that one.
National news?
Nope.
Blogs?
Nope.
So literally, according to you, you know zero about the media coverage concerning this case, Commonwealth versus Karen Reed.
Correct.
Can you speak about harassment? What specifically type of harassment are we talking
Phone call, constant phone calls, emails, awful messages.
I'll allow it. Focus on this witness, not Colin Albert at this point.
As far as you and your family, what, if any, type of harassment have you received?
People showing up at our house, people emailing my school, just like a lot of harassment. Can I have a moment, please?
Sure.
You spoke extensively to Chris and Julie Albert, correct?
What do you mean by extensively?
Did you speak at all?
Yes, we did.
Between then and now, to Chris and Julie Albert?
Do I speak to Chris and Julie Albert
Have you spoken to them about these events between then and now?
about this case? Is that what you're asking?
Yes, Ms. McCabe, I'm asking about this case.
Of course, I speak to them all the time about the vicious harassment we are all receiving.
Okay, but that wasn't my question. My question was, did you talk to them about this case, Ms. McCabe?
Yes.
I realize you want to give additional answers in the editorial. I'm asking you very specific questions.
So another interesting motion that was also filed, and I think this was also agreed to by both the Commonwealth and the defense. I could be wrong. Please correct me in the comment section below if I am. But I believe that they were unified in both agreeing they should be allowed to state their objection, which makes sense to me, because it's like otherwise you just have no idea how to navigate through the rest of the cross-examination or direct examination if you have no idea what the reason for stopping and stalling this entire time was. And it was so hard to follow last trial because you would get Bev even queuing up Lally, being like, hey, do you have an objection? And it's just like, for what though? For what? Let us in on what is happening, because if we don't know what's happening, the jury sure as heck does not know what's happening either, and why certain things might be objected to, because it does matter. It does when you're in the deliberating room and you're considering all these mitigating factors. So now jumping back into today's hearing.
No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony, to the extent that they did.
Or according to Jen McCabe, vicious harassment. The vicious harassment. I mean, I just get like anxious just listening to her speak. Like, everybody wants to paint her out to be this wholesome soccer mom. I'm like, she's the kind of soccer mom that I'd be like, is she bringing the snacks today? Because I just can't stand her.
Occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance.
And they also, too, not to cut you off for a second, AJJ, but they also recently placed the defense under a gag order. So anything that is currently being reported on from seemingly the other side of the field, of the playing field. I mean, it just so conveniently that the Proctor, the Proctor family interview dropped, right? They hired some PR company to do damage control for Michael Proctor's image, because nobody actually gives a flying duck about him and saving face in that regard. I mean, even if the Commonwealth is going to call him back on the stand, I mean, they're damned if they do, damned if they don't. His reputation is completely and utterly destroyed. He did that all by himself. He had no helping hand by the defense or Karen Reed, because it's all in the text exchange thread. It's all right there in black and white. It's all over that Sally Port video. There's tons of evidence to back it all up, and he even read some of those vile and disgusting things. So any kind of sling match that's going on the other side has not been perpetuated by the defense, but it's just come out because people's true colors do shine, right? And the same goes for these witnesses.
Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it." In some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider, an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed, very specifically, should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed.
And anybody who's going out there and spewing that stuff, because you see it all the time on like the Twitter X, and I don't blame any of you guys who don't want to cross that throughway. I totally get it. But like, has everybody? I just want to ask, like, for those people, right, who believe that Karen Reed is completely and utterly guilty. Like, have you ever seen her go up on a podium or make a video or put out a written statement saying, yes, all my followers, please go out, release the hounds now, chase after Jennifer McCabe because you have nothing better to do on a Sunday?
And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Miss Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable cause standard,
that.
right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment? And
was she co-conspiring with Aiden Carney? Because everybody likes to sling that around as well too online, like, oh, they're co-conspirators. Well, a grand jury did not believe that there was enough evidence to support that claim, thus why she was never indicted for that, thus why Aiden Carney was never indicted for that.
intimidation, and that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed...
When was that no bill issued?
You said when or where?
When?
When? I want to say March 23rd. March 27th is what I'm being told. It was late March.
By the way, that was Karen Reed that was just mouthing that date. So, like, she's her own, like, little paralegal there. And, like, it really is, like, go girl. Like, I love that she's so involved and invested in her own case because I think it's just, I really think it's 99% of the reason why she's got as much fight as she is just because she knows his case inside and out. And she really is a part of her own team.
March, before the first trial. And they knew this, and they didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So
Nope. Nope. Should we bring that clip back up again, Beverly? Because we got it. We got it on receipt, girl.
You spoke extensively to Chris and Julie Albert, correct?
What do you mean by extensively?
Did you speak at all?
Yes, we did.
Between then and now, to Chris and Julie Albert.
Do I speak to Chris and Julie Albert
Have you spoken to them about these events between then and now?
about this case? Is that what you're asking?
Yes, Ms. McCabe, I'm asking.
Yes. Like, what's with the hostility? Yes, that's literally what I'm asking. And in fact, that's what I asked your daughter. That's what I asked Cole and Albert as well, too. The two that also testified, I think, before she did. Yes, and I'm probably going to ask every other witness that comes onto the stand, did you talk to each other in between when the investigation kicked off until today's festivities? It's not a hard answer. It's a yes or no.
Of course, I speak to them all the time about the vicious harassment we are all receiving.
Okay, but that wasn't my question. My question was, did you talk to them about this case, Ms. McCabe?
Yes.
I realize you want to give additional answers in the editorial. I'm asking you very specific questions.
Objection.
Yes, you want to talk about it. You do, because you have something that you're trying to defend. You're trying to defend your own character there. Like, we all get it. We can all see that clearly. So no, Beverly.
If the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be very easy.
Read the transcript.
I mean, we watched the clip, Beverly. I mean, again, we can do this all day on loop. If you need to refresh your memory, or did the White Claw go to your freaking head, girl? Like, I don't know. You even went so far as to say, if the door does open, then let's have a sidebar discussion. They can testify if it comes up spontaneously, but let's go to sidebar and have a conversation about it.
I have several times.
It's like,
In
I
any
was
event,
there.
I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Miss Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript.
And everybody else's view, AJ, you're not alone in feeling that way. So, yes. And the fun keeps on going, folks, and it's only going to keep on continuing because we are getting closer and closer by the day to the potential start date of this upcoming Reed trial for the Karen Reed case. So with that being said, if you enjoyed today's content, make sure you hit that subscribe button, make sure you hit that notification bell so you do not miss the next Karen Reed update from me, and make sure you hit that like button because that tells the YouTube algorithm that this is newsworthy news, and it is quite literally because this is the garbage that the mainstream media wants to run with right now. See you in the next one.